While everyone likes to think that their family will peacefully and fairly distribute their assets when they are gone, this is usually not the case. Having a proper will in place can prevent this conflict and ensure everyone is treated fairly. Many people have never talked about their estate intentions with their heirs. This may be an uncomfortable task for some people, but it's important they know what steps you are taking to avoid unnecessary and costly legal battles later on. In Canada, if you die without will, you are deemed to have died intestate. And each province has their own set of rules as to how your assets will be distributed. Many people believe that if they die without will, their spouse will receive their entire estate. If you have children, in most jurisdictions, this is not the case. Generally speaking, a surviving spouse will receive a preferential share ranging from $50,000 to $350,000, depending on the province in which you reside. And the remainder will be divided between the spouse and children. For example, in Ontario, if you die intestate, leaving a spouse and children, the first $350,000 of the estate is paid to the spouse, and the remainder of the estate is divided between the surviving spouse and children. Before deciding you do not need a will, here are some common scenarios that may help you realize why you should consider creating one. No will, no executor. No one will have the legal authority to manage your assets until the court appoints an administrator. And the person appointed may not be the person you would have chosen. If you have minor children, a court will be required to choose who will act as the guardian. Your children will also have access to all of their inheritance at the age of majority, that is between 18 or 19, which is still very young. And in many cases, they are not mature enough to manage large sums of money. Individuals in blended families often mistakenly assume that stepchildren will inherit in the same way as a natural or adopted child, leading to many instances where stepchildren are inadvertently disinherited. And sometimes common law partners often assume that they will be treated the same as a married spouse at the time of death. Your common law spouse may not receive anything from your estate upon your death. And in the event of a common disaster, where both spouses die at the same time, a will alleviate the potential inequities in jurisdictions where the older spouse is deemed to have predeceased the younger spouse, and avoid the need to probate the same asset twice. Certain assets that you may have wanted to be kept for your family may have to be sold for distribution. Make sure the estate is properly funded. Permanent life insurance can be a great method to inject liquid funds into the estate. You should make sure your will contains the names of 2 powers of attorney, one for your personal health and the other for your financial health. The bottom line is you can avoid a host of potential problems if you simply plan ahead.